you might think that when a child dies, parents have a right to know as much as possible about the circumstance of its death. But according to the law on medical negligence, doctors are not obliged to tell the truth, even when youngsters are involved. Earlier this month, the House of Lords refused to consider an appeal by the parents of one child who died after doctors failed to diagnose his condition. As Lindsay Taylor reports now, the case has also provoked calls for the government to increase the accountability of the medical profession.
The Welsh Valley town of Ystrad-Gunlais. Children finishing their day at the local primary. Until 1990, Robbie Powell went to school here. Today, pupils pass a tree planted in his memory after he died from a rare medical condition. Robbie was 10 years old when he died from Addison's disease, a rare but treatable hormonal disorder. The condition is notoriously difficult to diagnose, and 5 GPs at his local practice did not spot it. But Will and Diane Powell's grief was compounded when they learned that 4 months before Robbie's death, Addison's disease had been suspected as a possibility when he was admitted to his local hospital, the Morriston near Swansea. However, as Robbie appeared to get better, he was sent home without ever being tested for the condition. The hospital's health authority later admitted liability and paid £80,000 in compensation. But Robbie's parents believed their GPs were negligent. They're convinced the doctors failed to act on information from the hospital and attempted to cover up their mistakes by altering medical records.
All I want is the truth. I want a full inquiry into the death of my son, and I want it established exactly what went wrong. I want the errors identified, and I want people to learn from these mistakes.
The GPs based at this practice deny any wrongdoing, saying in a statement that they set out from the start to fully inform Robbie Powell's parents of their child's illness and cause of death in a truthful manner. Dissatisfied that an NHS inquiry merely censured one GP, who's now left, and that a police investigation found no evidence of wrongdoing, the Powells began a civil action for negligence at the High Court in Cardiff, claiming that the doctors had breached their duty of care to them as patients by failing to tell the truth.
But the Powells' attempts to seek redress through the courts over the death of their son produced an outcome which has not only left them with a greater sense of injustice, but has also shocked many within the medical profession. For the courts have effectively found that in such circumstances, doctors have no legal obligation to tell the truth.
At the Court of Appeal, the 3 judges agreed that, in law, doctors had no freestanding duty of candour. Lord Justice Stuart Smith said, "I do not think a doctor who has been treating a patient who has died, who tells relatives what has happened, thereby undertakes the doctor-patient relationship towards the relatives." He went on, "If the relatives concerned happen to be on the doctor's register as patients, the position is no different."
Well, I think it's appalling and I think it's scandalous. Parents must know that when they take the child to a doctor and they don't have full confidence in what the doctor is saying, it must be challenged while the child is alive. Because if the child dies, the parents have no right, and the doctors can then lie about the events leading to the child's death without fear of litigation.
A leading professor of general practice is also aghast at the ruling.
I think the law is an ass in this instance. I can't understand this at all. It is effectively saying that a doctor can be false with the truth for his own protection, effectively.
But the ruling is a strictly legal one, which doesn't affect a doctor's ethical duty to be truthful, according to the medical body defending some of the GPs in the case.
It's very much a lawyer's case, and I'm not surprised that it is incomprehensible to many ordinary folk and to many doctors. But I do stress that it is a ruling on a negligence action. It is not a general statement that doctors have no duty to be frank with patients and with their relatives.
In 8 years, Mr. Powell has amassed volumes of material, including now forensic handwriting tests, which he believes support his case that medical records were improperly altered. But the court ruling denies him the chance to have that evidence tested. Ironically, it also denies the GPs the chance to counter it.
That is a great pity, because they would have welcomed the opportunity to lay the facts before the appropriate authorities and to clear their reputations and their good names.
The Powells, though, now plan to take their case to Europe.
On his deathbed, I told Robbie, "Son, I will find out what's went wrong. I want to fulfil that promise. But with this present law, it doesn't seem as if I will be able to. But I must fight on, not only for Robert, but for all the other children who have died in similar circumstances.
That report from Lindsay Taylor. Well, we're joined now in the studio by Dr. Michael Wilkes, Chair of the British Medical Association's Ethics Committee, and from his London constituency by the MP Simon Hughes, who has tabled a Commons motion calling for doctors to become more accountable. Dr. Wilkes, first, I mean, one would have thought that a child as a minor was really an extension of the parents, that the parents must have the right to know why their child died and the full truth to it.
Yes, I think in general that's absolutely right.
The House of Lords doesn't think so.
Well, the House of Lords, as was said, dealt with this in a strictly legal way and didn't mention the ethics, and I think the ethics of this are rather more important than the law, and it would be extremely unfortunate if the ruling gave the impression that doctors were hiding behind a rather strict and a rather dry legal ruling to avoid their ethical responsibilities. It's quite clear that doctors should always, except under exceptional circumstances, communicate the facts of a child's death to the parents.
Well, clearly the Powells believe that the doctors are hiding behind this strict interpretation of the law.
Yes, and I think that's very unfortunate because it's quite clear both from our ethical viewpoint at the BMA and also I think even more importantly from the General Medical Council, which regulates doctors and can discipline doctors, that truth-telling and sharing information with parents at this time is something that we would generally welcome as a very important ethical principle.
Simon Hughes, therefore, from the BMA's perspective, it seems that we have a distinction here between doctors' ethics and the law, that the law is too strict and that the ethical issues prevail. But you clearly see it otherwise.
I don't think families like Will and Diane are at all happy with the present position. It's clear they're not happy because they don't intend to let the case rest without going to Europe, and I don't think it's good enough. I understand the point that doctors may have an ethical or moral duty to go further than their legal duty, but I don't think that's a good enough public law answer. The reality is that when particularly children die in circumstances where there are doubts about the diagnosis, I happen to have had some family experience of misdiagnosis and death as a result, so I share that view strongly. It's important, firstly, that there is an independent inquiry into what happened, because there's a lot of self-interest, bound to be professional self-interest, in the doctors who were responsible, who may have made mistakes. And secondly, there must be a public interest in having in the open the facts about what happened, and the only way you can then, as it were, tie that back to responsibility is to say that the doctors, the professionals, must be held to account at least to give the facts to the parents or to the families.
The procedure you're following is not going to achieve anything, is it? I mean, we're not going to get any kind of change out of Parliament.
Well, I think we will, because we were waiting when I tabled the motion for this ruling from the House of Lords. That wasn't given at that stage, and it was would have been improper to try to anticipate it. It's now clear, and it has been given. Now that it's been given, I think there is a growing body of support across all the parties, and I think sympathy within government to change the legislation, and I hope that we can persuade government that the present system of accountability of medical practitioners, doctors and consultants just fails so often, and fails to give the answers to the questions parents have a right to ask.
Well, let me just quickly put that point to Dr. Wilkes. I mean, do you think, will you oppose legislation if he's successful?
I think a strict legal framework is unhelpful. I think both Simon and I want the same thing, actually, but what Simon is suggesting is an extension of the rather sort of large-scale inquiry. He mentioned the word inquiry. And I think to put it in that sort of context actually puts people into a rather defensive position. Medical ethics and medical procedures tend to work best on the basis of informality, and I think if we can continue that sort of information sharing informally and accept our responsibility to do that, I think it's better than having a strict legal framework for it.
Dr. Wilkes, Simon Hughes, both, thank you very much indeed. You're watching Channel 4 News, our main headlines tonight.